When I have done Chapter 7 business bankruptcies, of course, the first thing I do is meet with the client or the owner of the business, or sometimes it's a board of directors, and sometimes it's the main stockholders, and discuss strategy. So we go through a process of, let's say, if you could somehow restructure these debts, would the business succeed? Is this a business that just needs maybe some additional time, maybe a way to push the paying of debts out further into the future in some sort of structured fashion? The answers to those questions is yes. Then we're going to talk about a Chapter 11 bankruptcy. If the answers are no, this business is pretty much over. We've given it the good try, we fought the good battle, but this one is over, then we prepare the bankruptcy petition and the ancillary schedules. The business board of directors has to sign a resolution authorizing me to prepare and file the bankruptcy papers, and authorizing one of their members to serve as the person typically referred to as the person most knowledgeable at any hearings that we attend. And then I take from the board all of the relevant documents, tax returns for the last several years, list of inventory, list of debts, and prepare the documents. This can, as far as obligations go, this can also include leases, unexpired leases, and executory contracts. Then we file the documents, and then I send, once I know who the Chapter 7 trustee is, I send all of the documents, or at least copies of all of those documents, to the Chapter 7 trustee, so the trustee can get some sense of what's going on, what are the assets to be liquidated, and what is the long-term outlook for this case. Then something on the order of a month, plus or minus a few days, there's a hearing. It's called the meeting of creditors, sometimes referred to as the 341A meeting of creditors. And the reason for that is it's authorized under Section 341A of the Bankruptcy Code. And I'm there with the person most knowledgeable. That person will be sworn in and asked a series of questions. Generally, what the trustee is trying to do in asking these questions is to get some sense of what the history of the case is, what kind of asset profile there is, although given the thoroughness with which I prepare the papers and the fact that I send all the documentation to the trustee ahead of time, that questioning is usually fairly short. Now, because it's called the meeting of creditors, creditors are permitted to attend that hearing and ask the person most knowledgeable questions. Generally, those questions are designed to find out, are there any assets that weren't disclosed? What plans do you have to pay me after this bankruptcy is completed and I didn't get paid in full? And sometimes those colloquies can really get quite heated, especially if you've got some small investor that lent money to the business and now is left high and dry. And I've seen shouting matches break out at the meeting of creditors. In any event, eventually the trustee will conclude that hearing, although that might be after several continuations. The trustee in the meantime is going to gather all of the assets of the business, and this sometimes creates a challenge if there are lots of assets. Where do you store them? And so the trustee may need to assume a lease at the facility in order to have that place available to store assets. Then the trustee will advertise, trying to get people to come to an auction and buy these assets either in large blocks or piecemeal. And eventually the trustee will have liquidated as much as can be liquidated. Some things that simply can't be liquidated, the trustee will abandon. And I did have a case some years ago where most of the business assets were abandoned back to the principal because the trustee simply could not find anyone to buy them. So the principal now has those assets and can use them maybe in the future to start some different business with a different name, doing maybe similar sort of work. And then once the trustee has all that money from the liquidation, the trustee will review all of the proofs of claim that the creditors have filed in the case, and sort them according to priorities, because the bankruptcy code does give certain creditors better treatment than other creditors. For example, secured creditors get the best treatment of all because their claims are secured by physical assets. Then even within the unsecured realm, there are different priorities that are listed in, if you're curious, section 507A of the bankruptcy code. And then the trustee will propose a payout and file a motion to get the court's approval to do this payout. And of course, anyone who wants to can object to the motion, and sometimes those disputes can be quite heated. Eventually, the trustee will get permission to distribute the assets or distribute the money. And then after that's all done, the checks have all cleared, the trustee will file a final report, and the court will close the case without the debtor getting a discharge. Because remember, as I've said repeatedly, a business cannot get a Chapter 7 discharge. So that's sort of in a nutshell what the Chapter 7 process is for a business. Now, there's a lot more there. The whole process is really quite anfractuous. But looking at it down from 30,000 feet, that's really what's going on there.